judge grants the preliminary injunction. But wow, is there a lot more to discuss. Let's dive deep.
Conference realignment and expansion is always in the news, so we're back on the big mountain where we're going to break it down for you.
Hey, it's great to have you back. I am here with Steve. We are going to give you our thoughts and opinions on this hearing. We did a breaking news episode, or I did a breaking news episode a couple days ago when this first broke, and just gave the highlights of this, but we want to dig a little deeper, or a lot deeper, in what was said here. Everybody apparently now knows, the breaking news on Tuesday was that Judge Levy granted the request of OSU and WSU for a preliminary injunction, meaning that these two schools are the only voting board members of the PAC-12. He stated, and I quote, "The PAC-12 will be governed by the two universities that have not submitted their notices of intent to withdraw." We're going to dive deep into this. There's a lot that came up, especially with the attorney that was representing the University of Washington and the other 9 departing schools. But first, I want to bring everybody up to speed here real quick on things that have happened since that hearing. First, and not surprisingly, the University of Washington has stated that they will be appealing this decision. That really comes as no surprise to anybody, including the judge. I mentioned that in the breaking news. I'll go over that here in a minute. Also on Thursday, the Washington State Supreme Court issued a stay on Judge Levy's ruling after the University of Washington, working on behalf of the 10 departing schools, filed an emergency motion to stay, and that extends the TRO that has been in place since December. So if you don't know what a stay means, it basically means Judge Levy's
pause button.
It's a pause button. Yep. It doesn't go into effect yet. There's a stay on that ruling, so it then reverts back to where they've been, which is this temporary restraining order. So as of now, we still have 12 board members. Now, that's up for dispute, but we still have these potentially 12 board members. That court has asked for briefs to be filed by November 28th, and then a reply by December 8th. So a little bit of a shorter timeline than what our judge here in Whitman County gave them. So fortunately, that'll hopefully move forward here fairly quickly. And to be clear, this stay is independent of the appeal. These are two separate items going before the Supreme Court. One will be an appeal. As of us recording this, I don't think that has been fully finalized yet, but we all know it's coming. The stay has, and that is in order right now. So before we dig deep, I just want to say, Steve and I are completely unbiased here. Like, we don't have a dog in this race. We've been following this for 2.5 months pretty deeply. I know we've got some great viewers that provide some awesome comments, and I may say some things that Beavs and Coos fans don't necessarily agree with. You can throw apples at your TV screen. You can give me a punch through it, your computer screen or whatever. Throw your phone if you like. But I'm unbiased. I'm just calling as I see it. I know, Steve, you're going to do the same thing. You don't have to agree with us, but we do want to maybe bring some things to you from a different angle, because I know a lot of people like to read what they want to read and hear what they want to hear, and I'll be damned if anything else that anybody else says. So let's have a bit of an open mind here.
Yeah.
Can we try to do that? Maybe. Now, let's dig deeper. So, the OSU-WSU plaintiffs were represented by Eric McMichael, the same attorney that represented them for the temporary restraining order. The PAC-12 and commissioner were represented by Mark Lambert, again, the same attorney that represented them during that restraining order hearing. The University of Washington and the other 9 schools, through an amicus curiae, I'm sounding like an attorney, were represented by Daniel Levine. And I got to be honest with you, I was impressed by this guy.
I want to say first, you've been brushing up on your Latin. It's obvious.
I screwed that up probably. But McMichael annoyed me. Again, he kind of annoyed me in the first one. He just sounded a little whiny. And Lambert, honestly, I kind of felt bad for him, because really the defendant in this case is the other 10. It's not really the PAC-12. And you're going to hear he didn't have a lot to add to this. It was really the 2 and the 10 that were really going at it here. So the judge started things off. You're going to love this, Steve. The judge started things off with a ghost story.
Yes.
Because that's what he does.
Right.
He's a crazy guy from Whitman County.
He's folksy. I love it.
What did you call him last time? He was...
local yokel?
Local yokel. Yeah. The local yokel. Anyway.
I think what I said was I think a lot of people just assumed he was some local yokel, but he's been on top of it from the beginning. As far as he said that the other parties would want, basically everything he predicted from the first hearing has come true.
Well, and you're going to see in his opening statement, he knows exactly where this is going.
Yes.
Like, there's no need for us to talk. I know what I'm going to say, and I know what you're going to do, but we still talked.
Yeah.
So, he stated that no testimony would be given. He noted that the bylaws have this is really interesting, and he brought this up, I think, both for this hearing, but also, hey, other conferences out there, you better wisen up to what's going on. So he noted that the bylaws have no dispute resolution clause, which is crazy to me. Like, I would think pretty much all bylaws and contracts have that, but this one didn't. Or jurisdiction venue clause. Again, blows my mind when you're talking about board members in 5 or 6 or whatever it is, different states. Like, how do you not have a jurisdiction venue clause?
Billion-dollar industry,
Yeah.
multi-hundred million dollar conferences and billion-dollar industries and
Crazy.
simple things like that.
Yeah. Also, there's no liquidated damage or leaving early clause. So all of these things that would help in this ruling or hearing don't exist, which is why everybody's focused on this one quick definition of what do the bylaws say in terms of a notice to withdraw.
Right.
That's because none of this other stuff is here. And he, as I said, he made notice to other conferences, if you don't have these things, you better get them in your bylaws ASAP. I thought that was very astute of him, kind of giving a warning to everyone. He noted and sounded a little bit perturbed, a little bit frustrated that the University of Washington, I found this odd, like you're going to tick a judge off, they did, sent 75 cases to this judge with no synopsis.
Right.
It's just like, here's some cases, like, read them.
Like they're giving him homework.
Yeah.
Yeah.
He's like, I didn't read them, I'm not going to read them unless I get a synopsis.
Yeah.
So definitely a bad taste from that sort of thing. I thought that was pretty odd. He was hopeful that mediation, as I think everybody is, honestly, that mediation would occur, that a settlement could occur, and that they would not be back in his courtroom. Obviously, that wasn't the case because they were all standing there. He asked them if they had more time, and I mentioned this in the breaking news, and I actually didn't give the answer to this. I teased it and didn't follow up. But he asked them all if they had more time, would mediation be fruitful, and could they come to some sort of an agreement or settlement or whatnot? They all did answer that. They all basically answered it no, for now, no. And specifically, McMichael for OSU and WSU said, we need a ruling now in order to continue with mediation. We need guidance from the court now in order to have any sort of continued mediation discussions.
Because it's important to point out, this is a preliminary injunction. Like, we talked about at the beginning, if this is a journey of 100 miles, we're on like maybe mile 3 or 4 now at this point, potentially, if this thing plays all the way out. So, good point by them to say, we want to kind of have an idea of where this is heading, because we're still pretty early in the game.
Right. The last thing he said, and I mentioned this in the breaking news video, and this told me exactly what he was going to be doing in terms of granting this motion. He said, right before he tossed it to McMichael, that he fully understood that this case would likely be appealed and go to the Washington Supreme Court and then possibly the U.S. Supreme Court. He literally mentioned both of those. Yep. I went, boop, he's going to approve this sucker, and it's going to get appealed within that week. And we'll get into that here towards the end as we kind of summarize his ruling. So let's go into McMichael. I'm going to focus mainly on what McMichael said and what Levine said for Washington State, for University of Washington. I'm going to stop a few times, and please break in here, Steve. I want to hear, because there's really some really key points here. A lot of what McMichael said, and even Lambert, the Pac-12 attorney, was a lot of repeat items from the TRO. I mean, their case is still kind of the same. They did bring up some new items. His key points here, so again, McMichael is OSU, WSU, the plaintiff's attorney speaking right now. His key points were the likelihood to prevail with this mountain of evidence, which again, exactly what he said in the TRO, that there was a unanimous agreement on the bylaws until University of Washington left. You're going to see the University of Washington attorney debunk that. Again, I haven't seen them, but debunk that statement slightly. And then the irreparable harm to the plaintiff. So 2 of these things we've already talked about in terms of the TRO. That's exactly why they got a TRO. He stated the defendant's arguments, which is University of Washington, they're all a red herring whose interpretation of the bylaws is not likely to prevail. He stated the departing schools define a notice of withdrawal as an actual withdrawal. And to him, the problems with this are that it's not what the bylaws say. He referenced prior versions of the bylaws and what they meant by notice. Now, I will say, and then he went on to talk about prior bylaws and what they meant to be off the board. I think he slips up here. I mean, you and I talked about this a little bit. I'm not sure why he's bringing up prior bylaws. I mean, I guess he's doing it as this is how things have always been, like a precedent types of thing. But if the bylaws are a written contract and verbiage has been changed, which it has here in this portion in terms of notice to withdrawal and things, if it's been changed for a reason, and you can't go back to the old definition and say, well, this is what the new ones mean because that's what it used to mean. Right. That holds no water, and I don't know why he would do that. What are your thoughts there, Steve?
My first thought is I don't think he really needed to go into that again because we had already hashed through these arguments so many times, the briefs, and he definitely seemed to lock onto this. Now, what I will say, I definitely understand your point. Okay, we have a new set of bylaws. This is like a new version of the contract.
Right.
There is a lot again, neither one of us are lawyers.
Yeah.
But there are concepts of intent, and so lawyers will often make arguments, especially when something is vague, and this part of the bylaws is kind of vague.
Yes.
So then when it's not spelled out clearly, they can try and argue back and forth about the intent, and so that can be basically previous versions could be used, maybe not successfully, but could be used as an example of what the intent was, just to add clarifying information. And we see this all the time, actually, all the way up to constitutional law, where they talk about the founders and their intent, and they use when they're trying to rule if something is constitutional or not constitutional. They talk about Federalist Papers, that was not part of the Constitution. So I think that's just something that lawyers do. I've seen this often where they'll try and use some other information when there is a vagueness. Or if the two sides are disagreeing over what this sentence says, they try and add some other flavor in to
support your position some way.
Yes,
we're going to get back.
But I don't really think he needed to do that.
I think, and the reason I say he shouldn't have done it is because when we get to the University of Washington's attorney, he counters this with, it was changed for a reason, and here's the reason.
Right.
Now, I'm not going to get into everything that he said, but he's playing a little bit into the University of Washington's attorney's point here. I'm going to get into that a little bit, but not specifically.
Yeah, and that's why I said I don't think you need to do that, because anytime you make arguments, if you don't need to make an argument, you're just opening the door for a counter argument that makes you look dumb.
And I think
torpedoes your case.
I think that happened here. I was really surprised by this, and I think it was countered very, very well. But let's move on. So from June 22nd, he threw out a little bit of a timeline here. From June 22nd to August 23rd, there were 20 board meetings. I found this interesting because we obviously knew there were board meetings happening after USC and UCLA left. Define that as you wish. Left. Oh, how many board meetings did they miss? How many were they at? How many? He specified this and said there were 20 board meetings that USC and UCLA were not present on for that just over a year. This course of conduct, which I know is something you're going to be talking about here, and that's really his focus. This course of conduct was that they were removed from the board. Now, U of W will counter this, and I'll talk about that. He also stated that there was a discussion to penalize USC and UCLA for doing this and leaving early. Obviously, nothing came of that. What was the discussion? Was it one person saying, hey, we should penalize them, and 9 other people saying, what are you talking about? We have no idea. No. But he says that it was brought up at a board meeting. Irreparable harm. OSU and WSU would be deprived of the right to govern, and they would lose the rights to act as a board and try to save the conference if this preliminary injunction was not approved or granted. The plaintiffs are asking the judge to validate the right under the bylaws and recognize them as the only members of the board. That's kind of was his conclusion, right? Like, you need to validate our right. We're the only 2 members, and that's what we're asking for. I think we already knew that, but obviously he wants to make that point very, very clear. The second attorney to speak was Lambert. He's the PAC-12. commissioner attorney, again, he didn't have a ton to say. I almost felt bad for him a little bit because, again, this is between members, not so much the PAC. But he did state that since the TRO, the commissioner and the conference received unanimous approval on several important items, the items that he specifically was adamant needed to get done. They did get done, so he's very happy for that. He raised operations, or he stated that operations are going well, and an injunction would create chaos for operations of the PAC. He spoke out about collateral litigation, an injunction would create fear, uncertainty, and doubt within the PAC. And that's kind of all he could say. Like, he doesn't, they don't have skin in the game like the members have skin in the game. So he was talking, a lot of his conversation was about operations. We want to continue moving forward, or at least as is. An injunction will cause uncertainty. And that was his main thing. He just wants things to say as is.
I'll say for him and for the conference, in my opinion, less is best. Mm-hmm. I was very critical of him. In the very first hearing, we both were complimentary that he was able to get some stuff together and make arguments, but right. I was very critical of him where he really went out on a limb on that very first hearing. Right. Yeah. He tried to have it both ways, yes. saying that he's independent and he's neutral, that they're neutral, but then also made a lot of arguments and he was just opening the door right. for whichever side to say, well, you're saying this now, but you did this before. Mm-hmm. So less for him going into it. I was even wondering if they were going to make a statement at all.
Right.
I was happy to see that they said the part about that since the TRO that things have been going well. So yep. that means things have been functioning. I probably would have just stopped it there. Yeah. Less is best, but I don't think he did too much harm. So.
No, he didn't. He didn't get into some of the items that you were talking about the last time with the hearing. Like, he doesn't need to go down that route.
No,
he didn't do that at all. It was almost all about operations, maintaining operations. Don't throw a monkey wrench into the gears at this point. Everything's going okay.
Yeah.
Leave us alone. I mean, that's pretty much all he said. So I thought of you. I'm like, Steve would have loved this because, again, less is best.
Yes.
So let's get to what I consider the best part of the hearing, because we have not heard from the departing 10. And the attorney here, I got to be completely honest with you. I followed him completely. I was texting you. Mm-hmm. I went, this is awesome. He's reading this the way I read it. And I'm not going to get into that. You really have to hear what he has to say. I'm not going to sit here and read all the words that he said.
Yeah.
I will just say that the way he represented their understanding and definition of the bylaws, quite frankly, is the way I understand and read the bylaws. That doesn't make Beeves and Cougs people happy.
Yeah.
But his interpretation and the way he laid it out, to me, was spot on. So I'm going to start with that.
Yeah.
But let's get into some of the detail. He stated that a preliminary injunction was to maintain the status quo. Typically, that's to maintain the status quo. But the plaintiffs here want to change the status quo. It's not to maintain what they have. It is to completely change it. So kind of piggybacking a little bit off of what Lambert kind of spoke about, he went right into, hey, this isn't supposed to change anything. It's supposed to maintain it. He mentioned this action that they're bringing isn't about the future. It's about the current year. They are concerned about the current 23-24 year, getting through August 1st of 24. After that, it is what it is. But they are still fully invested, both in terms of revenues, in terms of schedules and competing. And they are the PAC-12 in this year. Whether you want to like it or not, they're still the PAC-12 right now. And he actually said this threatens irreparable harm on the 10 departing schools. So he kind of threw that back in the face of OSU and WSU and said, well, it might be irreparable harm. Well, he didn't say it might. He said, we have irreparable harm. You're claiming you do. We do, if this goes through the way it is for the current year.
Sure.
So let's get into a little bit of the bylaws. He said there's no violation of the bylaws if you leave on August 2nd or later. Nobody's violating the bylaws if they leave on August 2nd or later. He said there's no breach of announcing. There's no breach of the bylaws if you announce before August 1st. And I know what the Beeves and Cougs fans are going to say. It's the same thing. It doesn't say that in the bylaws. Again, it's how you read the bylaws, how you interpret them. And I get it. A lot of people are going to interpret them one of two ways. Yeah. Like I say, I interpret them similarly to the way this attorney presented them. Anything you want to add there yet?
I'll wait a little bit longer until you're done with her.
So the current bylaws, now we get into him kind of going back to what McMichael stated in terms of using previous bylaws. And he hammered what the current bylaws are. He read the paragraph. He said why they changed. If they wanted it in there, they would have kept it in there, but they didn't for these reasons. The current bylaws got rid of prior notice wording and changed it on purpose so that it corresponds with the media rights agreement. That's the way I've read this the whole time. Again, he said that in way more words than I just did, but he was spot on there. OSU and WSU interpretation would lead to a board of 0. And I would make the claim that if OSU and WSU did get an invite from those they were asking, I mean, we just did an episode about they were asking the ACC, they were asking the Big 12. Sure. If they also got invites from the ACC, it would be a board of 0 right now. And none of them would be in favor of that.
Yeah. I mean, all 12 of them could just then say, hey, this is a ghost, this is a zombie entity now, and ask a judge to dissolve it and split up the assets.
You could, but it's a board of 0.
Sure, yeah.
And under their definition, under OSU and WSU's definition, if they would have come out and they wouldn't have been the last, and everybody then, hey, we're all going someplace else.
Yeah.
According to this preliminary injunction, it's a board of 0.
Yeah. I would say because they didn't people can make the argument, well, they didn't do a very good job of writing these bylaws, like the judge said.
Right. They
didn't put in clauses for if there's a dispute or whatever. They put in one very vague statement.
Yeah.
And right now, we're this particular lawyer saying why it was changed or whatever.
Right.
But do we have meeting minutes as to why it was changed?
Sure.
Do we have documentation? So I'm sorry.
Again, he said, she said.
Yes, go ahead.
No, you're good. The board would and should direct any dissolution, according to the attorney here. He brought up some items that honestly would fall under that unclean hands doctrine that we talked about. He didn't use that term specifically, unclean hands doctrine, but he was circling right around it. I mean, everything he was talking about was right there about basically what I just said. OSU and WSU, they don't have clean hands either. And I know some of the comments were, well, yeah, but they didn't actually leave. Yeah, but they were looking to leave, and they wanted to leave, and they probably would. Maybe that's speculation on my part.
Ifs and buts were candy and nuts.
There you have it. So that part's a little rough for me. I think he makes good points there.
Yeah.
So course of performance said that this was really, really good, said that USC and UCLA responded to the dispute that they felt they should be on the board of commissioners and that the board of directors, and the commissioner was wrong. So everything you've heard so far from USC and from WSU and OSU is that, hey, course of performance, they got a letter from the commissioner and they accepted it and they didn't come to any meetings and there was 20 meetings and everything I said earlier. They completely disputed this. They did not sue the board. They didn't take action on it, but they did make it known that they did not agree with the commissioner. And he also said Colorado did the same in disputing this. That's huge. Now, again, I haven't seen the documentation. I don't know why. He certainly couldn't be lying to the judge. I would certainly think there's documentation that shows that they disputed these things. That was huge when I heard him say that. August 5th, 2023, a Washington State lawyer, again, August 5th, 2023, a Washington State University lawyer asked if anyone had issued a notice to withdraw. He's asking the conference, has anyone issued this? Clearly, that's in opposition of a course of performance. And he said it is clear that all board members had no idea what was going on. They didn't understand the bylaws. They didn't know who was or who wasn't on the board anymore. And it's backed up by this lawyer for Washington State University on August 5th saying, has anyone even issued a notice of withdrawal?
Yep.
He's asking. Again, very telling to me. It's clear. Oh, I'm sorry. And then the request that he gave 3 options. He said, option number 1, deny it, obviously. Option number 2, keep the TRO in place and have a hearing, a full-blown hearing. Item 3, or request number 3, the departing schools should have a voice in 23-24. So clearly he started with what they want the most, which is just denial, and then it kind of gets a little weaker from there. They went back and forth then for a while. They brought everybody back up, and basically it was just a pissing match between, well, he said this, and we say this, and you say that, and we say that. I'm not going to go over that again. But he did, I will say, the judge asked McMichael for OSU and WSU, can the departing schools sue OSU and WSU? And his answer was yes. They can sue him. Mm-hmm. He then made comments about subterfuge, and this is right before we're going to get to the ruling and some items with that. But he then made comments about subterfuge, and it doesn't encourage schools to keep secrets. The bylaws state that they should communicate in good faith and openly with fellow members. Nobody did that. All 12 of them didn't do that.
Yep.
So I don't know why he would say that when it's clear that OSU, and getting back to the dirty hands doctrine or the unclean hands doctrine, he should have never said that, because they fit right into the same mold that the other. Now they didn't leave. I know everybody's going to write, yeah, but they didn't leave. I get it. They didn't leave. They were all doing the same thing. They were not operating in good faith. Period. My opinion. You want to push back on me?
Yeah. Let me go back a little bit. So. First of all, and I've said this before, I said this with the Oregon State and Washington State attorney, I really think that, especially this hearing, they made some arguments that they didn't need to make. The irreparable harm, let's start with that.
Yeah.
And again, neither one of us are attorneys.
Right.
So these are just kind of our opinions and what we think on these things. The irreparable harm, from kind of just doing some research, reading some things, this is the easiest part of the case for the plaintiffs, in my opinion. Mm-hmm. And especially if you look back at the framing of what was going on when they first filed the TRO request and the preliminary injunction. There was a meeting that week or that coming week where the commissioner or the commissioners of the league office had invited all 12 members to come in. And at the time, basically everybody, the expectation was that they were going to come in and very potentially could just come in and say, hey, we're dissolving the conference at the end of this league year. Yeah. So that was the original part of the irreparable harm, was what they were trying to stop, the ability for those for the other teams to come in. Now, since that has happened and the TRO was granted and different things, the framing of the arguments have changed a little bit. I think that the other 10 have realized, well, that's not going to happen. They're not going to let us do this. We couldn't go into that meeting. That's not going to happen.
But that was never said in a court of law.
It was not said in a court of law. But it's just the threat, the opportunity for harm, the irreparable harm. What can happen if we allowed these 12 to do this?
Well, what can happen if you allow these 2 to do this?
Exactly, but one side is the plaintiff, and so they have to prove the irreparable harm of why they're trying to stop that meeting. Now, definitely, like they mentioned, the other 10 could countersue and try and argue irreparable harm, but that would be a different case.
Right. Okay.
So this case is about them trying to stop the 12 from basically taking over the meeting and dissolving the conference. That's the threat of the irreparable, and that was talked about in the very first hearing. And the judge asked, well, what would happen? What do you think would happen? What is the threat to you or to your clients if we allow this meeting to take place in the 12th? And that's what they brought up. So we've kind of moved past that now, but at the same time, we have to remember what the context was, why they filed it originally. So I really think the irreparable harm is the easiest part to show. And I think they did that very clearly at the TRO, and that's why the TRO was granted. Mm-hmm. And nothing that's happened, both sides, the arguments they've made either for or against that, nothing has really changed in substance. So that's the first part of it. And then what I'll say is I really think this comes down to, and it's what we talked about the first 2 or 3 episodes of this, is how do you read the bylaws, okay? And like you've mentioned a few times, you look at it as the literal when you read it, which is obviously what Washington and Oregon and the other members, as the literal meaning of what it says on the bylaws of you have to give notice. And they're saying, we didn't give you a notice. We didn't fax you a paper. We didn't give you a notification in writing. Don't really think it says it has to be in writing, but that we didn't give you official notice that we're leaving. Whereas the other side is making the argument, well, in your performance of, if the bylaws are a contract, as the way you are performing in practical application of the law, you are performing as you are leaving. When you notified the world that you are joining the Big Ten and you published your schedule of who you're going to be playing, whoever, you notified us and everybody else that just like putting a thing in the paper. And it's going to come down to a judge, in this case, Libby, but it's going to go down to the Supreme Court of Washington and maybe to the biggest Supreme Court of the land. How do they interpret that? And those arguments, and again, we're not attorneys, but they're the letter of the contract versus the practical application. Now, I think, especially in this hearing, Washington and their partners in this did a good job of trying to muddy those waters, of throwing some things out. But really, like they mentioned, USC and UCLA stopped coming to meetings. As far as we can see, they stopped. So they were performing in that way. They stopped coming to meetings. The commissioner's office, and this was, and I said this the very first TRO hearing, the commissioner's, the PAC-12's lawyer really stepped out on some limbs he didn't need to step out on, because he was trying to make arguments as far as that the commissioner and the league felt like they were still members, but they themselves had notified other members that they weren't members anymore, that they weren't voting members. So, and that's really what Washington and Oregon and the others are trying to do. We're trying to muddy these waters. They're saying that the way they've performed means that they left, and we're going to try and muddy that argument and hold it to the letter of the law. And and a lot of these other things are just extra. It's just a bunch of flowers. It comes down to that argument. And we're going to continue with the judge's ruling.
Yeah, I'm going to do that next.
Okay, then I'll stop there.
But I want to counter one thing on that. And I didn't put this in my notes, and you bringing that up jogged my memory, because the University of Washington's attorney addressed that. He addressed the fact that to act in good faith, I just read the last piece here in terms of what the OSU and WSU attorney mentioned in terms of the bylaws state that they should communicate in good faith and openly with fellow members. The University of Washington's attorney said that's exactly what they did. They didn't wait until August 2nd and drop this on them like a bad hat. They communicated with them. Now, I get it, where people are going to be like, no, they left them, they're holding the bag now. But he spun that, again, to your point, he spun that into they are communicating. The good faith piece, I get it. That's a reach.
My definition of good faith, yours, and
that's a bit too far. But again, to get back to the notice issue, would have it been better to have all 10 of these wait until August 2nd with no discussion, no notice, no anything, and then August 2nd, they're gone, and OSU and WSU are holding the bag with no notice.
So here's and again, I think this is just an attempt to kind of muddy the waters on that. If they actually would have given them a notice saying that we're leaving, that would have been the notice. So they didn't do that.
Right.
Instead, they announced to the world that, hey, we're leaving. We're going to the Big Ten. We're going to be playing these teams. We're so excited. We're not going to be part of the PAC anymore. We're going to be part of the Big Ten. We didn't give them an official thing on paper yet because we can't do that until after the date. But we just want all you guys to know we're leaving the Pac-12. And that's what, so the a little bit of trying to have it both ways. So it still comes back to that, again, the same argument. And I think you're going to get to his ruling.
Yeah, we'll do
what
that
he said is the letter of the bylaws versus what actually happened, the performance of how they were performing.
Yeah, I'll give you just a few of his quotes and what he said. So again, the ruling, everybody knows it, but he granted the preliminary injunction. He stayed the order until the end of the week, until the defendant could seek an appeal with the Washington Supreme Court. We just talked about that at the beginning, but he did stay that order for a few days. He stated, "This is not a shutout. The preliminary injunction is going to be modified to make sure the other 10 are still treated in a fair manner. Nobody is going to take advantage of somebody else. The 10 other schools also must be notified of all board meetings. They're allowed to attend the board meetings. They just can't vote in the board meetings." So that's what I kind of had on his ruling.
So there was a quote that he said while he was giving his ruling, and I was hoping you were going to have it. Maybe one of our viewers can find it for us.
Okay.
And I should have told everybody this at the beginning. We kind of did this a little different this time. You were following along the hearing, listening for most of it. I think you got cut off at the end.
Right.
I took the other approach because I knew you were doing that, and I actually was following along on Twitter. Because I knew there was a couple of reporters that were in the courtroom, others were listening, and I kind of just wanted to see like the reaction, get a different perspective, and see the reaction on that. So I was seeing quotes that people are typing. It's hard to know if they're paraphrasing or whatever.
Yeah.
But a quote, and again, I'm hoping maybe someone watching can get the exact quote for us. One of the quotes from him was, he said, "In my opinion of the law, actions speak louder than words, and your actions clearly show that you are leaving the conference. And so to me, that is, your actions are your notification." Something to that extent.
He started off with, "The way I was raised."
Yes, the way I was raised, yes.
Which I thought, are we freaking 5-year-olds right now? Who is he talking to? But he started it with, "The way I was raised, actions speak louder than words." And I'm glad you bring that up, because I did not put this in here. My first thought, again, is I'm not a kindergartner.
Right.
They're not kindergartners.
Yes.
Why the heck are you talking like that? My second thought is written documents speak louder than anything.
Well, I don't know that that's really true, though, in how law is interpreted. But that's the thing is, so in our system, we have an adversarial legal system, and then you have human judges that have to rule one way or the other. And there is a lot of legal precedence for how you perform a contract versus how it's written. If I had a contract with you and it said we're going to do A and B, and you did A and I didn't quite do B, how it was split up, but let's say we continued to operate that for 10 years and I kept doing it and you didn't say anything, you didn't question it. And then, at the end of it, afterwards, you sued me and said, hey, I'm suing you for not performing your contract because you didn't do B. And I would say to you, well, I kept doing, this is what I was giving to you. You didn't say anything. You accepted my payment. That's a big thing when you accept something or when you do something or not do something. So
I hear you.
So again, that's what I think it's going to come down to. And in this case, obviously, Libby, he's very clear with it, saying that in his mind, the actions speak louder than words. And so the other judges may not.
Did he throw out the action of them disagreeing that they weren't a member anymore? Well, that's an action, is it not?
It sort of is an action, but if you say, hey, I disagree with this, and then you don't go to them, if they really, then action would have been for them to show up at the meeting or file an injunction, but they didn't do that because they're leaving. They're going to the Big Ten. They're getting a full share in the Big Ten. They didn't do that. Okay. They didn't show up at the meeting. They didn't take any action at that point. They said some words. They gave them some more words. They said, well, here's some words, and we're going to give you some more words, but we're not going to do any actions.
Okay.
And so, and again, that's what it comes down to. In this case, Libby went with the actions versus the words. And I think when this goes to the Supreme Court, again, there's a whole bunch of extra arguments that they're going to throw in there.
Yeah.
But it's going to come down to, does the Washington State Supreme Court look at this and say, well, if they didn't give you official notice, then they're still members? Or are they going to say, we agree with the judge.
Right.
The way they're performing under these bylaws is that they've left and they're not members anymore. It's going to come down to that most likely.
And we're going to end this episode because we're getting a little long.
Yeah.
I'm making a prediction.
Okay.
And you can agree, disagree, or say, doesn't matter. My prediction is this will be appealed. That's obvious. It'll go to the Supreme Court of Washington State, and the Washington State Supreme Court will side with University of Washington. That's my prediction.
I would say if I was going to make it, I have no idea, honestly, what the Washington Supreme Court will do. No idea whatsoever. I don't know if it's a panel of judges or it'll be one judge assigned. I don't know how that'll work. But I'm going to stick with my prediction that I've been consistent with the whole time, is that they will eventually come to a settlement on this.
Oh, that's a cop-out.
No, it's really not, because it's really not, because here's the thing, is both of them have so much to lose.
Yeah.
And it really comes down to that fundamental argument that we talked about. And in this case, it shows that the first judge thinks it comes down to actions and that they've left.
Yeah.
And in the other case, or they're going to make the case when they go to the Supreme Court that they didn't give that notification.
Right.
The irreparable harm, there's really no arguments you can make to that. I don't see that coming into a play. And really, that's more of an argument for the TRO and a preliminary injunction.
I totally agree.
So that, at this point, that's just been established. It is what it is.
Yeah.
But it's going to come down to that. And it could go either way, where both of them could lose everything.
Mm-hmm.
It's not really very likely, if there is a ruling one way or the other, that it'll be in the middle. The only way they're going to come to a middle ground where they all get something is a settlement. So, yeah.
Well, and that's the part that just confuses me. A settlement here, if the 10 really just want their fair share for this year, how can we not agree on that?
So
how can we not agree on that?
We try and stick to, like, when we do these shows, we try and stick to, like, the facts that are coming out of the courts and all that. I have seen a lot of, like, rumblings and whispers, off the record stuff, that the big thing is that the 10 members, they want a part of the current year's revenue,
right?
And then they want to be fully released from any liabilities. And what the other members are saying, no, if you're going to walk away with some money, then you're either going to give us some money back to let you out of those liabilities, or you are going to retain those liabilities. So that's kind of, but again, that's just like a rumor mill rumbling.
Well, that makes complete sense.
People are kind of talking about
that makes complete sense.
And I think that's why, remember at the beginning, the judge asked, because the judge has said this from the beginning, like, you guys should come to a settlement, because one of you is just not going to be happy.
Yes.
Like, you know, if I have to cut the baby, I'm not going to cut the baby down the middle.
Right.
One of you is going to get the baby, and one of you is going to get no baby.
Right.
So, and he asked that, and I forget which lawyer it was that said, well, I think that having a ruling today will kind of show us what direction it is going, and that will maybe add some motivation to come to a settlement.
That was McMichael. That was OSUW, so it was kind of how he said that, or answered that question. So anyway, hey, well, we dug deep, Steve.
Yes.
Dug deep. So, hey, I know we probably upset some people. Hey, but that's okay. Give us your comments. Tell us what you're thinking. If you want to put a tomato out there, just put a tomato. You know, I think they have an emoji tomato.
Rotten
Pretend
tomato.
you're throwing it at me. That's okay. I can handle that. So, hey, we'll be back with a lot more of this. We'll be watching this. We're going to take this the whole way through whatever kind of settlement agreement or final trial, whatever the heck ends up happening. We appreciate you watching. We'll see you next time on The Big Mountain.